we've got two cases, correct?
Correct, Your Honor.
And you are Caleb Landry?
Sir.
In 23 CR 908, the earlier case, you were charged with the state jail felony of burglary of a habitation on or about February 14th, 2023. And that carries with it no less than 180 days up to 2 years in the state jail. You'll understand if convicted.
I think you said burglary of a habitation.
I said burglary of a building, state jail, a burglary of a building, not a habitation, a burglary of a building, which is lesser than a burglary of a habitation. That's no less than 180 days up to 2 years in the state jail. Burglary of a habitation is a second degree felony. Do you understand what you're charged with here in this?
Yes.
And in 24 CR 2225, filed on October 23rd of last year, this states that on September 17th, 2024, that you committed the state jail felony of burglary of a building. It's like the same building owner. The victim is the same as the previous case. And it goes on to state that you have, in this indictment, you've been convicted in 2005, felony offense of illegal possession of marijuana, a state jail felony out of Harris County, Texas. And in 2015, you were finally convicted in the criminal district court here of delivery of marijuana. And that doesn't affect the on this, does it?
Yes, Judge. If he's
Two prior state jail felonies on separate.
Makes it a third
So,
degree.
well, your punishment range is in two things that are problematic. Your punishment range will be enhanced if this is proven true to what would be a third degree felony punishment. It's state jail felony, but it's punished as though it was a third degree felony under law. And you were looking no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Plus, if this is true, you are not eligible for probation in either of these cases. Do you understand?
Sure.
Okay, there's a lot on shit in your mind here. What are we going to do today?
Your Honor, the state has tendered an offer of 12 months or 1 year in the state jail facility. And
How much time does he have credit, if any? Please. Okay, go ahead.
and Mr. Landry's advised that he's refusing that. Is that correct?
Okay.
You don't
That's what you want to do?
Speak up.
It's hard. It's your life. Right now, we're at a crossroads. It's either going to go that way or this way. Which one?
To be clear, one thing that hasn't been stated, he is not eligible to receive probation from a jury.
I said that.
If he continues down that path, I'll withdraw the state jail offer and give the enhancements on both cases so that they're both dealing with third degree. Sure.
Okay, it wasn't. Yeah,
It wasn't in the first indictment. For some reason, we must have recovered them by the time he committed alleged second offense.
He has 17 days credit.
okay, not a lot.
Not a lot.
Let me ask something here. What's his bond?
What are your bonds?
$5,000?
Each? Probably 5 each, Your Honor. I would have. That's what he seems to.
He's correct.
Okay. When was this bond posted? In 908. I'm looking at July 15th of 2024, correct? Is that right, everybody? That's what I'm seeing.
It's right.
It's $5,000
He's alleged to have committed the second offense while he was
in
on bond.
September. Yeah, we got a bond issue. You committed, according to the grand jury, and this second offense after you had been charged and in this earlier case, and you posted a bond of $5,000. Let's see, stand by. Looks like the amount of bond was fixed at $25,000 on July. I'm looking at another document that says July 20th.
He made the accusation that run the initial arraignment may have been 20. I'm
There's a 715 of $5,000 on 7 that he paid on 7/15, but then there's a warrant for an arrest, a capious burglary of a building filed on July 16th. Okay. And the bond was fixed.
He probably
It
got
says the amount of bond fixed by the court in this case is $25,000 here. Right?
that was probably the initial arraignment. He didn't postpone.
Yeah, it was an arraignment.
And he got out on accusation after that in the warrant. Sometime after he was released on accusation in the bond.
But it's showing
On the warrant.
5,000. Is that right, Lacey? It's showing 5,000 on this? Okay.
When he was arrested on.
And all of this was done though before it is alleged that he commits this next crime, 24 CR 2225.
He may have been out on the accusation on the second offense.
No, the second offense is on or about September 17th of 2024. All this is July.
Which the initial bond he made in 908 was made on 7/15 of 24,
Yes. Of,
$5,000.
yes. Then what?
And then it looks like the bondsman surrendered that bond when he was rearrested, and he made another bond in this case on 2/10 of 25.
Of how much?
The initial bond was
No, I'm talking about the new bond.
it wasn't an AFRS, it was a surrender.
Oh, all right.
Is it showing it's still 5,000? Yes.
Yes,
Okay.
still 5,000.
Okay. And then when did he post the bond in 24, 22, 25?
The judge is basically discovering in real time that the bond situation on this case is a mess. He thought he'd set a $25,000 bond with GPS, but the paperwork and follow-through don't match that. We're seeing a rare moment where the judge is not just mad at the defendant, he's also clearly frustrated with the system. Clerical changes, bond surrenders, rearrests, and missing GPS enforcement. Question for you, when something like this slips through the cracks, who do you think should shoulder the blame, the court staff, the bondsman, or no one as long as it gets fixed later?
The new one.
10 of 25,
What was that bond?
5,000.
Yes. Well, on what day now?
2/10 of 25.
That's after the,
That indictment had already been
right,
prepared and has those prior convictions, and then you have that.
right.
It just slipped. It must have slipped by somebody. See, on this indictment, here's what's, once again, I don't know how this is happening. On this indictment, on the face of the indictment, 7/20/23, that's me writing it. When I get the bond, I'm setting the bond at $25,000 plus a GPS device. Do you even have a GPS device? You don't even have that. I don't know what are my orders doing here that aren't being followed. I don't understand. But this was my orders on July 20th of 2023. Thereafter, those are changed. Or
I didn't have anything to do with it.
you didn't. Yeah, you're the first suspect, but you've been
Like-
cleared in this
I would
one.
like to-
Anyway,
I don't have any notes to explain, Judge.
those were being changed without, and this court had authority over this case, and somebody else was changing these.
It was post indictment, yeah.
It was post indictment after I had signed these orders, which are equivalent to an order, which is inappropriate, but we'll figure it out. This court doesn't find $5,000. I mean, I put $25,000 up here, but I did this before this indictment shows up.
Right.
And then this indictment shows up another burglary of a building, which is alleged to have occurred on or about September 17th of 2024, after he was on bond here. Your bond's $100,000 in each case. Plus you have to have a GPS device as a condition of bond. So this is irresponsible and of your part. Once you are charged with a crime and a bond is set, and you're innocent unless found guilty. But these are probable cause decisions by the grand jury that you probably committed these crimes, which are what we base bonds on, as the probability a crime has been committed. And we use the circumstances of the case and the criminal history. Your first bond of $5,000 is the same type of offense that you post a bond a few months later, you're committing another of the same offense, same type of offense, as though none of this mattered to you. You weren't taking it seriously. You are now. We're going to take it seriously. You can't just keep committing crimes and think that you can just pay a small bond and not that additional information and additional crime commission won't have a bearing on it. It does. So those are the orders. You have a GPS device, and the bonds are amended to $100,000 each because of your criminal history and the fact that you're committing the same crime after you posted a bond in the first case of a similar matter. Just a few months after that, you're committing the same kind of crime, according to the grand jury. Anyway, that's the orders of the court. Next event, you set these for trial. It'll be set for trial. Thank you. That's what we'll do.
Bond on each case plus mandatory GPS. The judge is sending a loud message. You don't get to pick up new charges while you're already out on bond and expect the system to shrug. Legally, he's tying a new bond amount to two things. 1, the grand jury's probable cause that these crimes happened. And 2, the pattern of repeating the same type of offense while on release.
All right, next is Mr. Landry's cases.
Right has an add-on from earlier this week.
Monte Madison.
Judge, we spoke before today, but we've received a new offer. Do you want to take their new offer, or do you want to?
Can you give me that name of the investigator again? I'll give you what's suggested. Thank you.
Okay, he'll take the offer. He hasn't signed up yet, Judge, though.
Okay, get him signed up, please.
Yes, sir.
Dior Frazier
Dior Frazier, Judge,
is, yeah, just have a seat. He'll get with you in a minute and sign this up.
This is what Ellie handed me
Thank you.
as far as the investigator, but I don't know if.
Are you? Come on up, Ron Bacote. Is that you, sir?
Yes, sir.
Are you here with your attorney, Mr. Grove, and the state's attorney? Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that on or about July 6, 2024 in Jefferson County, Texas, you operated a motor vehicle in a public place while intoxicated, and it was occupied. The vehicle was occupied by a passenger younger than 15 years of age, and it says 3 paragraphs. It looks like 3 children were younger than 15 years of age.
That's correct, Your Honor.
This is a state jail felony, which carries with it, if convicted, confinement of any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand, sir? An agreement has been reached in your case where you would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years, and you must serve, is it 30 days?
Yes, Your Honor. That's what's recommended. Yes.
And you've requested that on weekends.
Yes.
Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal. You understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
No, sure.
Without objection, it's submitted.
Notice how fast this goes once there's a plea agreement. This defendant is accused of driving drunk with 3 children. Under 15 in the car, that's why. It's a state jail felony, not just a regular. DUI. The deal: 2 years in state jail suspended, 5 years of probation, 30 days in county jail on weekends, and a Wubai fine.
Among other things, the state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes.
State's Exhibit 1, part of the record for all purposes. Without objection. Pre-sentence report is waived.
Yes, sir.
I'm going to follow this agreement, sir, if nothing further, and find that you today, Mr. Bacote, are feeling or entering your guilty plea voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony of operating a motor vehicle while intoxicated with a child under 15 years of age. I'm following this agreement. You were hereby sentenced to confinement in the state jail for 2 years. That is suspended. You are placed on regular probation for 5 years. There will be terms and conditions of probation, which are normal and customary. You must pay a fine of $500, and there's an order that you shall serve 30 days in the county jail. This begins at 6 o'clock, on or before 6 o'clock each Friday, and then they let you out on or before 6 o'clock Sunday. So you get credit for 2 days on each weekend. That's the way that works. When can you begin that?
Not this weekend, and that's the next weekend.
Yeah, what is the date? It will begin on Friday week.
That's gonna be.
I think the 27th.
27th.
This begins on Friday, 6/27, June 27th of 25. Do you understand everything that has happened today, sir?
Yes, when I go to turn myself, where do I go to do the weekends? Do I
County.
I mean, county jail, but do I go to the back where the police take you in?
I don't know where, I don't know.
I think that is where they go around the back there.
Do you know?
You go to where you go bond out. There's a parking lot over the side.
Sure, if he puts
No, I
in
don't-
front of the jail, they can tell him where.
Right, yeah.
They'll route you. And in fact, we informed them they will be expecting you. They know
Yes.
they just can't walk in and say, need to go to the jail. They've got to have documentation that supports it, and we'll have that. So they'll know about you. And
As you go in and look to the jail, it's over on your right, extreme right. And it's where attorneys go to visit, but not family visitation place.
okay. Anything else? Please see the probation officer. Good luck, sir.
He's talking to you. See this lady here.
Mr. Ardoin, that's you?
Yes, sir.
Come on. Okay. Looking at this stuff here, you had, you're still wishing to represent yourself?
Yes, sir.
Okay. You've asked for an investigator, and I thought I had that ordered, just,
You did.
but I don't,
Well, I'm Judge,
Thursday.
has someone been in contact with you?
I have it. This was the day that I was supposed to get the side counsel as well as meet the investigator or get the information for them.
Who did I name as your, standby?
You didn't. Today was the day that we named them.
John West.
Is it?
And John is out today, Judge.
What are you doing? Have you talked to John West
No, I
yet?
haven't.
He's out. He was out today. That's the problem. But he's been assigned to help you. I'm going to ask him to go by and see. Please ask John to go see Mr. Ardoin as soon as he can. He will. His name is John West. He's a very good lawyer, a very nice man, and a very competent man. He will be He'll talk. He'll go over with you what that means on standby counsel and what he does. But he still has to go over with you to make sure that, because you're held accountable to doing the things right. And a lot of times people who aren't doing this every day don't get it right. And that works against you. You're not punished, but you are disadvantaged. And when there's a doubt about anything during the course of any procedures or steps in this case, including at trial, you are allowed to refer to him and get, like your lifeline. You phone a friend to help. You're going to be held accountable. As you represent yourself, you're going to have to know the law, the procedure, the rules of evidence. I help write the rules of evidence. So this court expects people to follow them. And if you don't, then you have a disadvantage. So he's a very competent man.
Representing yourself in a felony case while sitting in jail? The judge is basically saying, you want to play lawyer? Fine, but you'll be held to the exact same rules as a real one. No special treatment, no, I didn't know the rule. And on top of that, the defendant is complaining he can't properly access legal research tools because of his housing status. So he's trying to be his own attorney without a law degree and without full access to research.
Judge, I want to say that Ellie has already obtained the investigator, and
Let's see if she's in the back. She's gonna have a whole lot more.
Keeps talking about the investigator, but it doesn't name who it is. Yeah, I granted an investigator for Mr. Reynolds last year in September.
That was after I moved forward as pro se. But if he never acted, you granted 2,500.
Investigator. on
Get the
Mr.
list.
Ardoin.
We had discussed wanting possibly the lady who did foreman for Burbank. They gave me her information. It's a cell phone and a name, but
Who
I
is it?
did not reach out to her. I handed it, I think Lacey just handed it to you.
Okay, we'll give him, well,
He can't, that's just it. I don't know how, should I give it to John and have John?
No, please.
Don't
Not sure how-
talk about it. No, let me make the decision. So, no, I need to tell her what I'm going to do first.
Okay,
I need to talk to her directly, tell her what the plan is, so she's not in the dark.
So she knows how to communicate
Yeah.
with her
Yeah.
client.
But what is her name?
I don't know, you have a piece of paper that Missy handed you just a little bit ago. It's an email from
The one who
bank's
handles
office.
Clayton
It's an
Foreman?
email. It's just a white sheet of paper. Looks like an email right there on top. Turn that over, maybe. You did just hand it. Yeah, right there.
Oh, Brenna. That's Brenna.
Yeah, she is local and that was an issue. I wanted to make sure it was something. But I will,
She handled a very
yeah, that was a hard one.
prominent case in this county. That was televised by national television.
I know she.
That's going to be her. So when she comes to see you,
What's that?
right, yeah, that's the way I do my ends.
Hanson.
Hanson, yeah, Hansen.
She was the investigator and I got the murder.
So I'll call her right after this. Okay,
Okay.
hold that one for me
It's the rest
and
of
we'll
it.
get that
And the paper.
over. What else do we need to do? That's,
Judge, today I gave Mr. Ardwan a pretrial notice with the information that he requested. I also filed that notice and noted that it was delivered by hand delivery here in court today. The other thing, Judge, and I've tried to run this down for Mr. Ardwan at his request, he needs to be able to conduct legal research
say
and
that again?
he needs to be able to conduct legal research. And I'm not sure he has access to what he's needing at the jail. And I'm not sure how to facilitate that.
What do you need?
Well, they have, I think it's case text or whatever. There's a kiosk that they use, but being my housing, the housing that I'm assigned, I'm only allowed hours a day, but it's not for that. So if, I don't know, they make
all of their
means or something.
and this is Captain Ponder at the jail, I think would be the person that would know the most about
Ponder?
this. Is that fair?
Yes.
Yeah. Okay. And so Mr. Ardwan has explained to me is that all of the legal research at the jail is digital. And because of where he is housed, he is not able to access the kiosk that has this digital information.
A tablet, they have tablets also.
Right.
It has to be approved for it to be provided for me where I can use the tablet to conduct my legal research.
I'll call them, look into and find out what the deal is on that. We've never had an issue before. They've always been working with folks. I don't know what the,
They had rolling kiosks, but something's been wrong with them since Captain Miller's no longer there and they haven't had anyone to fix those. And they said it'd be a while before it'd be fixed. So those are not being able,
oh, you can't. So it comes to you.
they had those, but something wrong with those. I think, so I don't know what the issue is, but, and the captain that was over that, Captain Miller has retired. but
Bruce
they haven't
Minner.
had anyone to fix those.
And
So
Bruce Minner did retire recently. So, I mean,
So
what he's saying matches up and he knows the people that I know that
Okay.
are in charge of that. So
Give them a call here in a little bit to try to get that worked out.
appreciate it. As far as the standby, Council John West is, there's no way I can get anyone else other than him.
No, you don't get to choose. You get a competent counsel. That's him. I don't know why you would think he's not, because he's a very competent man.
I'm sure.
And if it's the talk in the jail, they don't know what they're talking
I
about.
don't listen to it.
Good. That's in your best interest because I seldom find anything intellectual coming from some of those folks.
So do I.
You sound like you're way ahead of me there. Okay. Yes, sir. No, but he's a good man. He's a competent man. That's who I have on my team of indigent representation. They're good, competent people.
He was the first one that was available on the wheel.
I get to choose who it is. Yeah, he's not on that wheel like that. He's a public defender.
Right.
They are the public defenders or who I sign. There's just a small group of them and those are my choices
Okay.
that help. The others they're competent people. They're all competent people. But I have 3 or 4 on each district judge has 3 or 4 that we get to choose. That's who I choose.
One that's good. She's already aware of the being granted some. I just called her. She's already aware of everything.
I know I hadn't even talked to her. I'm going to talk to her in a little bit. I hadn't even talked to her about it. I'm just giving you that information. Somebody shows up, says, I'm your investigator. That's who it's going to be. So you'll be free to, it won't be somebody who's trying to get information from you unobtrusively or improperly. She's going to be the one assigned to do it. Okay.
Yes, sir.
Thanks. Anything else right now?
Are you still needing to review more media?
Yes, I did that day. I guess because of how long it took for it to come down there, I didn't really get to view any of it. Very small.
Well, the next time we do not have a docket where people are occupying that room, we'll make sure to arrange.
Going back in 2 weeks to see where we are on things and make sure that everything is running right for a review. Okay. Okay. Thank you, sir.
Thank you.
David, you got some things, right?
Yes, sir.
Okay.